Carol Beaumont.
I rise to speak on the Criminal Procedure Reform and Modernisation Bill third reading, and note, of course, the bill was divided into 15 bills at the Committee of the Whole House. And I do want to follow the comments of my colleague Charles Chauvel, who indeed played a very important role in getting this bill to the point it is now, where it does in fact have the ability to pass through the House with reasonably broad support. And I will also have some comments about the wider implications. But before I get into that, can I say that the bill was an attempt to overhaul criminal procedure in New Zealand, and it's the legislative result of the Criminal Procedure Simplification Project established in October 2007 by Labour to review criminal procedure in New Zealand, and undertaken by the Ministry of Justice in collaboration with the Law Commission. So I do make that point to a couple of members opposite who said that Labour haven't actually done anything about this issue. I think actually we set in place a process to do precisely this. So we voted for this bill, the Criminal Procedure Reform and Modernisation Bill, to Select Committee, and I was a member of that Select Committee, to give careful consideration to it. It's a very large bill, 526 pages, where 72 submissions were received and 35 heard. Many of those submissions are very technical and detailed by practitioners who were indeed very, very concerned about some of the human rights implications, some of the changes that would have denied those defending themselves the right to justice. And so we heard some very serious submissions in the course of this bill. And of course the bill then was stalled really because in fact a number of parties, Labour, Māori, ACT and Green, were all concerned about features of this bill and those real threats to people's rights to justice and a fair trial. And so I have to put all of that on the record really. Just before I move off the process we went through, I would acknowledge, as I have earlier, the work of officials, my fellow Select Committee members and indeed the Chair and the Minister, because we have got to this point now because the Minister did finally listen to those concerns, and as my colleague Charles Chauvel said, that was probably as much a political reality for him. He had to, because there were such significant concerns, but at least he's done that. He's considered those objections, and we now are in a situation of being able to support this bill. But they were serious objections around issues like jury thresholds and around proceeding in the absence of the defendant, which have been changed during the committee phase of this bill. Now, the Minister talks about a careful balance, and that is of course very, very important with anything to do with criminal procedure, because we are balancing the need of, or the quality of justice and the right to justice for defendants, but also for victims. None of us actually benefit from undue delay in the process. None of us benefit if the system is outdated, unwieldy or overly costly. So, getting that balance is right, and so certainly it is a more balanced bill than it was, and that's a positive thing. I do think it's disappointing that the supplementary order papers put up in the name of my colleague Charles Chauvel were not picked up by the government. I think that is a real mistake. And some of them were very, very sensible provisions, codifying or formalising the processes around sentencing indications, for example. Why would you not do that? I don't understand. The reality is that there is more to do, and there is no doubt that this House, probably sooner rather than later, will be doing more work around the criminal justice system. And there's a number of reasons for that, because there still remains outdated legislation. There still will always, of course, be the need for changes that result from changes in society or changes in technology. And one of the things we grappled with in the Select Committee and really didn't get sorted was the whole issue of name suppression and the internet, and who was accountable and liable for that issue. And we haven't really nailed that. If we're all honest, that's going to be something that we will have to deal with in the future. But more importantly, the reasons that Charles Chauvel gave are the reasons that we will be dealing with this matter again sooner rather than later. And that is that we are dealing with the issue of crime is a complex one and has a number of dimensions to it. And you must certainly deal with the whole. And a number of submitters made that point. You have to look at these things in context, and clearly looking at the drivers or causes of crime is a fundamental part of criminal justice reform. And we do need somebody with a real reforming zeal in this area, and I do hope in the future that that will be my colleague Charles Chevelle, because it is really important that we address these issues. And I recently had the experience of visiting Arohata Prison with Charles Chevelle, and it was really very, very informative, that visit. I hadn't been to a prison before. We got to speak with a number of the women in prison at Arohata, and clearly the issues around the context in which crime happens and what we need to do were very clear to me. Many of the women there talked about the violence that they had in fact suffered. Many of the women there have got alcohol and other addictions that fortunately they can deal with at Arohata, unlike the other two women's prisons in New Zealand where there is no drug and alcohol treatment facilities in Auckland and Christchurch, but at Arohata there is. And many of them were dealing with those addictions. But when we talked to them about what would make a difference when they'd served their sentence, it were things like being able to get a job, things like being able to lift their skill levels, seeing a future for themselves, being able to get on a different course. And of course, those are things that this government is performing very, very badly in. This is a government that hasn't focused on jobs, hasn't focused on an economic plan that delivers jobs for New Zealanders, hasn't addressed the issues of skills and lifelong learning opportunities, the sort of things that would make a difference to those women in Arohata. So I say that we do need to look at the criminal justice system from one end to the other. I absolutely concur with Charles Chevelle on that point. And this bill, of course, will make some positive changes, will save money, will save time, will therefore have benefits to all of those involved in the criminal justice system. But it is one piece, and really probably the wrong piece to have started on. I leave my comments there, Mr. Chair.